he said that the kids weren't with me when the kids were consistently with me 5 days out of 7 days a week. Counselors and teachers were screaming my kid's name to make sure that I wasn't picking my children up for school. So now I'm looked at as like some type of creep or individual, and I'm not allowed to get my children. And I have 50-50 custody of them. So why don't I have access to my children with that?
At the start of the hearing, the father's attorney argued that his client had never harmed the children in any way. He explained that there were no allegations of physical abuse, no criminal background, and nothing like being listed on any offender registry. The attorney emphasized that despite this, the father was still being treated unfairly in the case. He also pointed out that his client was paying a significantly higher amount of child support than expected. The calculation difference was questioned, especially since there was a large income gap involved. The attorney did not understand how such a big financial difference resulted in only a minor adjustment. He further stated that the court had focused too much on the father's marijuana use. However, he argued that no proper safeguards, such as testing, were put in place. According to him, the children were still young and not capable of making such serious decisions on their own. The father believed the mother had misrepresented how often the children stayed with him. He insisted the children were actually with him most days of the week.
Court would note the appearance of Attorney Podolsky on behalf of the plaintiff and Mr. Jewell on behalf of the defendant. This matter is before the court on the defendant's motion to expand parenting time and for joint legal custody. Mr. Jewell, go ahead.
Your Honor, thank you. This has been quite a journey on this case. The court remembers we actually filed this motion late 2019, early 2020, had a motion hearing at the height of COVID. My client was understanding at that time that one minor child was diagnosed with, I believe, leukemia. We slow played visitation given the obviously unknowns and scariness of both COVID and the child's diagnosis. We had hearings, we had motions, we had agreements. We tried to expand parenting time. My client, again, continued to understand that this would take some time, but now here we sit 4.5 years later. My client did a incredible number of visits at the center, which I attached the notes to my motion, all of which went positive. And here we still sit where he's not being given the opportunity to have any kind of unsupervised parenting time because the other side simply won't agree to that because first it was COVID and the leukemia, which we understood, and then it was my client had mental health issues, so he had to do a psychological, which he did, found no issues. Then it was the children weren't ready, and that was about 2 years ago. They had agreed to get them into therapies. Therapists apparently have no goals they're working on with the children, according to the therapist. And here my client sits at this point, still not being allowed to have parenting time that would be unsupervised. He understands, given the trajectory of this case, that it probably wouldn't start out with multiple overnights, but he's even asked so much as to have like a lunch with the children without mom present. And that hasn't happened. We would like some type of schedule, Your Honor. Ultimately, I believe without a direct schedule placed by the court on how this is going to go, I'll probably file another motion in a year and we'll be sitting here asking for expanded parenting time again, because every time we've agreed, it's sort of been stall. And I understand that my client messed up back in 16, 17, 18 by not exercising appropriate parenting time. He regrets that. He's trying to make up for it, but isn't being given the opportunity to do so. In terms of legal custody, Your Honor, we still feel like we're hitting a brick wall at times with being able to talk to certain providers. It was sort of moving mountains, even with the court's previous order that my client was allowed to have medical information to get the therapist to talk to him. And even in the answer that plaintiff's counsel filed, it references a HIPAA violation in paragraph 18 for getting those psychological reports. So we continue to have those roadblocks, have those things. My client simply wants parenting time and he wants a step-up schedule. We would ask the court to put one in place so that this can just get taken out of the party's hands, because it appears that they're never going to be able to agree to a plan where my client gets actual parenting time, not everybody's family at the zoo or going to a baseball game where the children are playing, which are all great things. But my client wants to build that relationship and he simply can't, because mom is always there when parenting time happens, whether it be at the center or those games or even at the zoo trip with the families. So my client currently is remarried. The children, it's my understanding, it's a little unclear to me, but it's my understanding they still have not fully met his new wife. My client also has another child with his new wife, which the children have met. So he wants the children to be able to build a relationship with their sister as well. So, Your Honor, that's simply what we're asking for today, is some type of accelerated schedule here so we can get this thing moving forward. Thank you.
Okay, Ms. Podolsky, I have read your answer, but anything else you'd like to add?
Yes, Your Honor, thank you. First, as it relates to legal custody, as we stated in our answer, we believe that the plaintiff or the defendant failed to allege any facts that would address the custody factors that would warrant a change in custody. We believe he failed to meet the burden of proper cause and change in circumstance, and that request should be denied. But what is at the heart of this motion is parenting time. And it is correct that in the fall of 2019, the party's son, who was very young at that time, was diagnosed with cancer. Prior to that, defendant already had not been availing himself of parenting time. And then during the treatment, there were very, very strict guidelines because of the pandemic. And he did not avail himself of the guidelines, whether because he couldn't or he wouldn't, but he did have video visits with the minor child.
The father then described how his relationship with his children had been affected by these claims. He explained that teachers and school staff were calling out the children's names to make sure he was not picking them up. This made him feel like he was being treated as a suspicious person. He expressed frustration that he was being denied access to his children despite having shared custody rights. He questioned why he could not see them freely if he legally had equal custody. The court then formally noted the appearance of both attorneys representing each side. The judge clarified that the case was about expanding parenting time and deciding legal custody. The father's attorney was invited to present his argument in full. The tone of the courtroom became more structured as legal arguments began. The attorney thanked the court and prepared to explain the long history of the case.
Or both children. And counsel is correct that there were several adjournments during that time because the party's son continued to undergo treatment and the pandemic itself continued. But when the minor child completed his treatment, the parties entered into the stipulated order that they are following now. They agreed to find therapists for the children, which have been done. They agreed that they would participate in that therapy if needed. They've not been requested to participate. But what they also agreed is that the parties, the therapists, and the children would agree when parenting time should expand. The problem we've run into in this case was no therapist was willing to participate in any sort of court-ordered agreement. Everybody was concerned, I don't want to have to go back to court. I don't want to testify. That's not why I'm here. I'm here to treat the children. So the parties did find a therapist or therapist that they were comfortable with, but these therapists will not participate in any sort of court proceedings. But again, in this order, the next statement is the parties agree to work at the children's pace. At this point, the defendant father has had 18 hours of visits in 13 months. He has been invited to and informed of all extracurricular activities. In 2023, he missed his daughter's entire cheer season. He's attended 9 of 24 baseball and softball games. All of these opportunities have been made for him, and he is not participating. When the center, which is Family and Children's Services, had to change the time, they offered several options to the defendant to change the time and date that he would meet with the kids, and he would not avail himself of any of those opportunities as well. So at this point, we don't believe that the defendant has availed himself of all of the parenting time offered to him, and there's not been strict compliance with the stipulated order. there's not a parent-child bond between these children and the defendant. And unfortunately, this started well before their minor child was diagnosed with cancer, but that only further aggravated the situation due to defendant's lack of participation in parenting and treatment during that time. The children are very apprehensive. They do not want to have unsupervised visits with the defendant. We are not to a point where that can occur yet. But we also understand that there is a concern that we don't have a counselor who's willing to participate in a court proceeding. So we are recommending that the parties participate with Margaret Hunter. We understand she is someone who will operate via Zoom. I understand defendant does live out of state, and so that can be convenient for him. It can work on reunification, actually building a bond, and also co-parenting between these parents. But at this time, we believe the current order should remain. It can be amended to include Ms. Hunter as a new counselor for this family. And we're also willing to agree that supervised visits don't have to occur at the center. We understand that's in Battle Creek. Neither of these parties actually live in Battle Creek. My client is willing to continue to supervise visits out in the community. That can be a more relaxed setting than being at a center. And so that is also something that can be done. But beyond that, we believe the motion to expand parenting time and joint legal custody should be denied.
Okay, thank you. Mr. Jewell, what's thoughts as to having Ms. Hunter involved?
Judge, first I would say that my client did everything he could. He lives in Huntington, Indiana. He also works a full-time job, so he did come to everything he could. And the times the center gave him were times that he scheduled to work. So that was why he couldn't change to the new schedule.
Okay, well, let me ask you, because Ms. Podolsky suggested that you don't do it at the center anymore, but
Sure.
that mom would supervise it out in the community or different places. Is that something that's acceptable, at least on a temporary basis?
I guess at this point, Your Honor, he'll take what he can get, but the difficulty is that we don't even understand why there's a necessity for supervised visitation. Ultimately, my client didn't do any harm to the children. It's not like there's a physical harm or he's on the sex offender registry or any of those things. It was simply that, and he admits this, and he takes responsibility for not exercising visitation back then.
The father's attorney explained that the case had been ongoing for several years. He reminded the court that the motion had originally been filed around 2019 or early 2020. At that time, the situation was complicated by the COVID-19 pandemic. Additionally, one of the children had been diagnosed with a serious illness, which made visitation more difficult. The father had been understanding and patient during that period. The attorney stated that they intentionally slowed down visitation due to health concerns. Over time, there were multiple hearings, agreements, and attempts to improve parenting time. Despite these efforts, progress remained slow. The father continued to cooperate, believing things would improve eventually. However, years had passed without meaningful change. The attorney stressed that the delay had become unreasonable.
But he hasn't harmed the children in a physical, he's no danger to them. Ultimately, the parents don't get along, and that does concern him in terms of her being the one supervising the visits. We just don't even at this point understand the need for supervised visitation. But what we're really asking for, Your Honor, is some kind of plan, because I agree we got into a circumstance where we agreed to find a counselor who would work on a plan, and then all the counselors said, we're not going to participate in that. And when my client asked the counselors, are you working on goals of unsupervised parenting time and bonding and relationships, the therapist said, no, we're just doing whatever therapy the kids need. We're not working towards any goals. So that ultimately becomes a concern for my client. Is 4.5 years in here, now we're saying we need to do additional therapy. Kids are resilient. He's not saying it's going to be comfortable, and he's not even asking for overnights right away. He's simply asking for this to have a plan moving forward. So, I mean, ultimately, Your Honor, we're at the mercy of the court. We understand that. My client understands that. He just wants parenting time. And again, takes responsibility for the past. He would take umbrage with some of the things that were said, but I don't know that getting into a back and forth about who strictly complied and didn't is going to get this family any closer to having a normal relationship. So we will accept what the court does, but would really ask for some type of movement forward after 4.5 years.
Okay. Well, I think as we move forward, a court will note you had stated your client had a difficulty getting access to records. Well, that's provided by statute at MCL 722.30 that he has a right to all of those, so he should be able to get that. The court would order in this matter that, as suggested by Ms. Podolsky, that Margaret Hunter would get involved in some reunification counseling. That might be a step in the right direction. And Ms. Hunter has obviously testified a number of times, so she wouldn't have the issue that some of the other ones have had in this matter. The court would allow the supervised parenting time to occur in the presence of the plaintiff as opposed to Family Children's Services. Hopefully that gives some more flexibility in this matter. The court's not going to change the order other than that extent at this time without having an evidentiary hearing. So the court, in looking at this matter, does not believe that proper cause change in circumstances has been provided or even alleged to acquire joint legal custody. So the court's going to deny that. But the court will refer the remaining issues of parenting time, which are always subject to modification pursuant to Shade versus Wright. The court will refer that to the referee for a hearing in this matter, and that would be for parenting time and support to the extent that any change in parenting time would impact the support as well. Ms. Podolsky, I guess I'll ask that you would prepare that order and submit it and under 7 days.
Okay, thank you.
Thank you. You're free to go. Have a good day.
The attorney continued by highlighting the father's efforts to maintain contact with his children. He mentioned that the father had attended many supervised visits at a designated center. Reports from those visits were positive and showed no concerns. Despite this, the father was still not allowed unsupervised time with his children. The opposing side continued to resist any changes. First, the restrictions were COVID and the child's illness. Later, new concerns were raised about the father's mental health. However, after evaluation, no issues were found. Then the reason shifted again, claiming the children were not ready. The attorney pointed out that this excuse had been used for over 2 years. Even therapy sessions for the children had no clear goals related to improving the father-child relationship.
215 parens E parens 1, specifically, how did he fail to do that?
Your Honor, my client is in the position where she just believes that the best interest factors were not taken into consideration on the facts of the evidence due to the fact that the supervised parenting time should have taken place at a much longer basis rather than the step-up period that this court ordered. So what she's really asking is this court to set that part aside in relationship to, one, extending the supervised parenting time for a period of at least 6 months, keeping the defendant in this matter I want to say almost under the eyes of the court due to some of the things that have been going on. He hasn't exercised the parenting time that he was supposed to pursuant to that order. In addition, the other issue is that the court spent many times talking about the marijuana use of the father in this matter. However, there's no safeguards for the minor child, such as testing. So those are the two situations which my client believes that that statute was not followed.
Well, the referee likewise spent time on the fact that your client had had some addictive behavior in the past, and he did not do anything to ensure that she wouldn't engage in that either. So at least he was consistent, I guess.
That's true.
Okay. Mr. Parham, anything else, any response that you have?
I think the court order was fine how it was. I've been exercising parenting time correctly. I just haven't been taking the full 2 hours that I'm allowed to take. Sometimes the visits would be like an hour and a half, or sometimes they'd be an hour. But besides that, I don't have any disagreements with what was already ordered by the court.
Okay, thank you. Well, it's clear from the objection that the plaintiff was not happy with the referee ruling order. However, just being unhappy or dissatisfied with the results is not a basis for objection. I did read through the approximate 150 pages of transcript from May 8, 2024, June 12, 2024, and July 2nd, 2024. The referee gave an oral finding consisting of 19 pages, and therefore the referee did comply with MCR 3.215 parens E parens 1, which provides that the referee may make a finding on the record or in writing. The referee made a determination of the established custodial environment. The referee went through the best interest factors as required by MCL 722.23. The referee then made a finding on the parenting time factors as required by MCL 722.27A, and the referee determined that initially supervised parenting time was appropriate, and if the defendant was consistent and with each of the step up in parenting time, that this parenting time would be phased in. As I read through all of the record in this matter, the court does not see that the referee the court would note that the referee did make a well-reasoned finding and did not make a factual or legal error in this matter. As a result, the court will deny the motion in this particular matter. Mr. Parham, you're going to have to do an order, which you can submit under 7 days, stating that the court has denied the motion to set aside the referee recommendation. Well, you actually won't. Court will have an order to that effect, so you don't have to do that. You're free to go.
Okay.
Have a good day. On the defendant's motion to change custody, parenting time support, and motion to show cause. Ms. Huffman.
Thank you, Your Honor. That's correct. We did file those two motions. Since we were in court last, the oldest child, Damani's been missing school. Excuse me. She's already been suspended twice. She's currently on her second suspension. And that's been within 2 weeks. So she had 8 referrals and 2 suspensions within the first 2 weeks of school. But all of last year, she had 14 referrals in total. Dad remains extremely concerned about his daughter's educational well-being. He wants to nip it now sooner rather than later. It appears that mom is incapable of either getting the older child to school or having her remain in school, attend classes. She's missed a significant amount of school, not even counting the suspensions. She's missed a lot of school, and both suspensions, my understanding, is for assaultive type behaviors, like fighting. And to be honest, it's not surprising since Dad's been missing from her life now for probably about 3 weeks. So yeah, mom's bringing the children to school. So the other part of our the other motion is for show cause. So mom is bringing the children to parenting time at the location that they're supposed to meet. However, she's not encouraging the children to get out of the car. It's not good enough to just bring the children. If you're not capable of parenting the children to get out of the car, obviously you're not capable of parenting the children to go to school, to not get in trouble, to not get fights, to not get suspended. Then there's issues going on here, and they need to be addressed sooner rather than later. We are asking for sanctions for mom not getting the children to go to parenting time with their father. These children are 12 years old, and at 12 and 9, I believe, and you don't get to just make your own decisions when you're 12 and 9. They should be listening to their mother, and if they won't listen to their mother, they will listen to their father. So I'm asking for sanctions for not following the court order, and I would ask the court to set the other motion for evidentiary hearing. Thank you.
Okay, thank you. Mr. McGordon, what's your response?
Yes, Your Honor. My client has been showing up to the...
The father's attorney explained that his client was not asking for immediate full custody or overnight visits. Instead, He simply wanted small steps, like having lunch with his children without supervision. Even these basic requests had been denied. The attorney stressed the need for a clear schedule set by the court. Without a structured plan, the situation would continue to stall. He warned that they might end up filing the same motion again in the future. The father admitted that he had made mistakes in the past by not using his parenting time properly. However, he now wanted to correct those mistakes. He was trying to rebuild his relationship with his children. Unfortunately, he was not being given a fair opportunity to do so. The attorney argued that progress required action, not delay.
But again, my client is still doing her best to make sure the minor children go. She shows up to the exchanges every time, and they simply refuse to get out of the car to go with the defendant father.
Okay, thank you. Well, the court notes that based upon the pleadings in this matter, as well as argument, that the Vodvarka threshold has been met for an evidentiary hearing, so the court will set an evidentiary hearing in this matter. The court will note that the present order remains in place until that hearing, and both parties must comply with that order or risk going to jail. So it's up to the parties as to whether they wish to comply with the order or spend time in jail.
The discussion then shifted to legal custody issues. The attorney explained that the father faced difficulties even accessing basic information about his children. Medical providers and therapists were not cooperating with him. This was happening despite court orders allowing him access. The opposing side even claimed there were privacy violations when he tried to obtain records. These obstacles made it harder for the father to stay involved in his children's lives. The attorney emphasized that his client only wanted normal parenting time. He also wanted a step-by-step plan to rebuild his role as a parent. The father had remarried and started a new family. He wanted his children to build a relationship with their stepmother and sibling. However, constant supervision and restrictions made that impossible.
At this point, we'll just be in touch with the attorneys and set a time for that particular hearing, and we'll address everything at that point. So we will be in touch with both of your offices.
Your Honor, just if I may, for the record, we already do have an evidentiary hearing scheduled for the 17th, I believe at 8:30. Do you want to just set those for that same time for judicial economy or no?
October 17th?
Yes, Your Honor, at 8:30, and the minor children were to be interviewed by you at 8 a.m.
Okay. Yeah, we'll set them up and just do it on the 17th. We'll just address everything at that time.
Okay, thank you, Your Honor.
I probably will be in touch with your offices because just in chance, if we only have the 17th set up, all of these things have a tendency to go long. So we'll get another day as well so that we can have a backup date.
Okay, thank you, Your Honor.
Okay. Thank you. You're free to go. Have a good day. Court will note the appearance of the plaintiff. The defendant has not appeared, nor has the defendant answered in this matter. Mr. Roush, just looking at this matter, you've alleged that your concerns were not taken into consideration and that your time was reduced, but you haven't identified what legal or factual error the referee made. So what, if any, is the legal or factual error?
I'm not sure the correct terminology to put in for that, but what was what happened was nothing that I stated in our court proceeding was considered. I feel everything that she stated, he took in and gave her exactly what she wanted. We have split joint legal and split physical custody. We had 182 and a half days each, and the mother lied and said that the kids weren't with me when the kids were consistently with me 5 days out of 7 days a week for the past 3 years. And now I only have them every other weekend during the school year and that's what she asked for. And I asked to continue on our week on week off basis, which would make it so it's still 50-50. And I don't, I'm just not understanding why. What am I doing wrong to not get anything?
Well, let me tell you what happens is, from what you've said, you haven't given me any more than what's in your petition saying that the referee made an error, but you haven't told me or identified any error that he made. Just because the outcome isn't what you want doesn't mean he made an error. And I don't have anything before me to demonstrate that he made a factual or legal error. The results in and of themselves do not denote that there's an error. It just denotes that he changed things and made something different. But I can't assume without your identifying the particular factual or legal error that an error occurred. So unfortunately, at this point, I'm going to have to deny.
The mother's attorney then presented her response. She argued that the father had not provided enough legal grounds to change custody. According to her, there was no proper cause or significant change in circumstances. She insisted that the current custody arrangement should remain. She explained that the child's illness and the pandemic had created strict visitation guidelines. During that time, the father did not fully participate in available opportunities. Although he had video calls, his involvement was limited. She acknowledged that therapy had been arranged for the children. However, therapists were unwilling to participate in court proceedings. The agreement between both parties was to follow the children's pace. She claimed that the father had not consistently taken advantage of visitation opportunities.
The motion, and you're going to have to, if there's something else that's changed, you can always file a petition in this particular matter, but I just can't, based upon what you've alleged in your motion or has told me today, I can't assume that he made an error.
Well, I'm sorry.
I mean, you have to identify the error. You have to identify why it's an error and allow the court then to.
I'm sorry. I'm not trying to cut you off. I'm sorry. I was just trying to not forget the points. I'm sorry. I'm unable to pick my children up from school now due to the court order that's in, and I actually I don't know who to talk to. That's why I filed the motion, because I didn't know, I don't feel like I was listened to, or I'm not sure what consists as an error. But I can no longer pick my children up from school. When I rode past my children's school one day when they were out after hours, I actually just was riding by. The counselors and teachers were screaming my kid's name to make sure that I wasn't picking my children up for school. So now I'm looked at as like some type of creep or individual, and I'm not allowed to get my children. And I have 50-50 custody of them. So why don't I have access to my children with that?
Well, you can always file a motion. That's probably what you're going to have to do, is file another motion to identify what it is you want, why you want it, and why you believe legally that you should have that. And then the court or the referee could consider it. But based on what you filed at this point, I can't. Okay?
Yes.
Okay. Thank you, sir. I will, you're free to go. Have a good day.
Thank you.
Their services. That is not the mandatory condition of employment that the child support formula intends. He is being paid by his employer at that rate, or at least was before he was dismissed due to attendance, and therefore the rate should have been the case. In fact, Your Honor, as well, all of this was disclosed well after he mediated this. So the proper sequence of events should be that he signed the order he mediated to, and then he can always file, as is procedure, a motion with this court to modify his child support order if he believes that there is an issue moving forward. However, at the time of mediation, those were the mediated facts, and that is what is stipulated to.
Okay.
Yeah,
go ahead.
yes. The pay stubs clearly indicate that the deductions, okay, then those were provided well in advance of mediation. So the fact that it became an issue after mediation does not mitigate the fact that the documents showing the significant deductions from my client's paycheck were provided well in advance of mediation. It was only after we received the calculations and we noticed that significant deduction was not factored in that this became an issue.
Well, what the issue now is, he doesn't work there anyway, so he's not working through that temp agency, is my understanding. Is that correct?
That is correct, Your Honor.
Okay.
I don't believe he's employed.
I still work there.
He's what?
I still work there. They just
Sir, you have an attorney, so don't speak.
Oh, yes, sir.
Mr. Holek, he's not employed through the temp agency, so that's not an issue now. Is that correct?
That is correct, yes.
Okay. Well, what the court's going to do is, obviously, I would state for everybody's information that obviously if he's through a temp agency, he's being paid through the temp agency, and whatever that amount is the amount of his income. So regardless of the fact that the employer may be paying the temp agency something else, a different amount, if he's not receiving it, then that's not income to him. So, but at this point, I guess it's academic because he's not being employed through the temp agency now anyway. So what the court will do is I will enter the judgment of divorce and the UCSO as submitted in this particular matter. If in fact he becomes employed through a temporary agency again, then you'd have a right at that time, Mr. Holak, to come in and seek a modification of the support to the correct amount of his income. But at this point, the court will impute that amount to him as the amount from the employer, because the temp agency is not deducting anything at this point. So that will be the order, and you're free to go. Have a good day.
Your Honor, are you asking that I prepare a new UCSO, or are you able to enter as submitted the UCSO?
No, we'll enter the UCSO. It sounds like that is what was in place at the time of mediation. If in fact he was still at the temp agency, I'd have you recalculate, but he's not. So there's not a deduction at this point. So we'll enter the current judgment in UCSO.
Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day.
The judge then gave the final ruling on the matter. The court acknowledged that the father had the right to access certain records. It ordered that a new counselor be involved to help with reunification. The judge allowed supervised visits to take place outside the center for more flexibility. However, the court refused to grant joint legal custody at this time. The judge stated that there was not enough evidence of changed circumstances. The case would be referred for further review regarding parenting time. The court emphasized that these issues could still be modified in the future. Both parties were instructed to follow the current order strictly. The judge made it clear that failure to comply could lead to serious consequences. Overall, the court aimed to create a path forward while maintaining caution.